Hey everyone, welcome to Lawyer Up Podcast. This is your host, John Ting. Our next guest earned a bachelor's in cell and molecular biology from UT Austin. Now, with that degree, you would think he is a patent lawyer. However, he actually practices criminal defense law here in Houston, Texas. I actually share an office with him as well, and so that's how I've gotten to know him. Lawsons, if you need any help, he is your go-to because he actually earned a spot on the dean's list every semester at South Texas College of Law. Fun fact, he is a competitive volleyball player and a gamer. Now, knowing his background and experience, he's certainly very dedicated to his practice and to his clients. We've asked James Kahn to be a guest today. Now, we've invited him because we like to learn more about the nuances of criminal law in of itself, and also what he is able to gather from the different charges and the enhancement of charges from third degree to second degree in the case of George Floyd as the victim and Derek Chauvin as the defendant in Minnesota. So without further ado, let's hear from James Kahn. Well, hey, James, welcome to Lawyer Up Podcast. We appreciate your time.
Thanks for having me.
Yes, and we to share with the audience, we actually share an office together, and for the past year, and known each other for at least a year before that. So, can you tell everyone a little bit about your own practice?
Sure. So our firm is called Wynn & Kahn. The firm is me. I'm James Kahn, and Don Wynn is my law partner. We're a small firm. It's just the two of us. We do a wide range of handle a wide range of legal issues, everything from civil contract disputes to criminal law. The balance of my practice is criminal defense. Don handles a little bit more civil, but we do practice in both areas.
Right. Now, I asked you to be a guest today because we would like to focus on that criminal defense part. And with your experience, and especially with the recent news of death of George Floyd, and among others, but for today we'll focus on George Floyd and the charges against the officer. I believe his name is Derek Chauvin. And are you familiar? I know we all know that you practice and have a license in Texas. So the caveat is, of course, you don't have the specific experience in Minnesota, but is there, I know you've done some research. Is there some insight you can share with us on the charges in general?
Sure. So from basically just news reports and just doing a little bit of reading, Mr. Chauvin was originally charged after quite an uproar under Minnesota's laws with third-degree murder. The requirements in Minnesota for third-degree murder, as they charged him in the criminal complaint, were that he committed an act that was inherently dangerous to human life with reckless disregard, and it actually caused the death of another human, Mr. Floyd. The requirement as charged does not require that the state prove that he intended to, and in fact, it's not a requirement the way they charged him at all. So that was the initial charge. There was also a lesser included offense charged in there of manslaughter as well. Those were the initial charges. A couple days later, the charge was enhanced or upgraded, and they charged him with second-degree murder. That carried a slightly different requirement for what the state was supposed to prove. As charged in the second-degree murder, under Minnesota laws, what it was saying is that the officer, in the act of committing a felony, caused the death of another individual. It's also known as the Felony Murder doctrine, basically, in simplified terms, saying that if an individual commits a felony, and in the course of committing that felony, another individual is killed, despite the fact that he may not have intended it, and his actions may not have met murder under any other definitions, that's sufficient to charge an individual with murder.
So let me ask some questions there. Sure. To unpack that a little bit more. Going back a little bit when you earlier said that they had a lesser included offense of manslaughter, do you think that the district attorney's office did that because they think there's a possibility that a jury would not find him guilty of the first charge of the third
Uh,
degree murder?
it is possible. I mean, whether or not that was explicitly necessary, it depends a little bit. You have to remember that during the initial phases of this event as it unfolded, charges were not initially forthcoming. I suspect that the initial charges may have been at least in part motivated by the public outcry, which is both a good thing and a bad thing in such that it required such an outcry for the motivation. But it's
Mhm.
also nice to see that, when something with relatively, clear evidence in terms of the video that was released showing that, most members of the public that looked at it saw that, that's probably a crime.
Mhm.
Obviously, there are very specific requirements required for a guilty verdict, as however Minnesota's laws dictate. But most people obviously felt that some sort of crime did in fact happen, and charges did eventually get pressed um, and were filed. Uh, I suspect that the DA's office was not entirely sure what they would be able to get a guilty verdict out of, and so they did include both the third degree murder and the lesser included offense of manslaughter. Uh,
Now, to be clear, for those that don't practice law at all, I don't practice criminal law at all. So just to unpack that a little more, if a district attorney does not include a lesser charge, that means, uh, well, James, this is a question to you, but I'm just prefacing it. But if the charge was only third degree murder and a jury, even if it was one person, did not find him guilty, then that make sure I'm saying this right, but then that person's not guilty, right? It has to be unanimous.
um, that may differ a little bit from jurisdiction to jurisdiction. I can't answer for sure, but um,
Hmm.
the way a crime is charged, in theory, the state could at trial amend and add a charge,
Okay.
because it is possible to get a conviction on a lesser included charge of a greater charge even without initial filing. But at trial, if the requested instruction is made, it can happen. And the way generally that works is, and oftentimes such a request might come from a defense. Uh, Say, for example, someone is charged with murder, and we go through a trial, and that there are issues raised that say, well, maybe this element of murder isn't proven, but there is enough for manslaughter. Such an instruction and request actually might come from a defense saying, "Hey, look, he's guilty of manslaughter, but not
Hmm.
murder," and it may be a strategic decision saying, "Hey, look, uh, you know, the state's probably going to ask for it anyway. It's very much going to be there, and so it's a more palatable decision for a jury saying, hey, we understand that someone died here. We kind of don't think that the state has actually met their entire burden to get all the way to murder, but we have enough for manslaughter." So it doesn't necessarily have to be charged now, but it doesn't hurt the state much, in my opinion.
Okay, so in that sense, when you said it can be done, or the charges can be amended to include a lesser or in, let's say, an enhanced charge during trial, in that same token, could that, if they include a lesser charge, for example, would you say that's a possibility because the defense team provided some kind of evidence to help their cause?
At this point, I think that's unlikely. Um, I doubt very much, especially when the complaint was first filed, that the defense team, if it even existed at that time, had any contact with the DA's office. I think the initial charges were entirely at the discretion of the DA's office.
In your experience, I'm sure you read a lot of police reports or incident reports. I've read in this case with George Floyd that the police report included information, for example, about the height or in the like biographical type information. Do you think they're trying to add that kind of descriptive information because they're trying to lead a jury a certain direction? Because from what I read, it made it appear like they're trying to give the officer a benefit of doubt.
It's possible. I can't say for sure. I mean, offense reports are, in theory, originally generated and drafted by an officer. They may go through revisions before a release is made official. I don't know that I've actually seen the offense report itself. I have read the original criminal complaint. There was some biographical information noting, I believe, Mr. Floyd's height and weight.
I'm probably referring to that. My apologies.
It is a little strange to see that in a complaint. I don't know that it necessarily makes a difference. The complaint itself is not evidence. I mean,
right.
It's not something that a jury technically considers. I mean, if the defense wants the jury to consider Mr. Floyd's height and weight and size, that's something they can certainly bring up in testimony. But it was a little odd to see it in a complaint, but I don't know that it will ultimately have any effect in the long run.
Well, in general, can you help unpack what a complaint is versus an indictment? Sure. I think in some jurisdictions could be similar, but
yeah, it may differ from jurisdiction to jurisdiction, but at least in Texas and several other jurisdictions, there's a slight difference between a complaint and an indictment. A criminal complaint is just the initial filing made by the prosecuting agency's office. So the DA says, we've done an investigation, here are the facts, this is just the initial phase, we believe that there are facts that support third-degree murder. And so they'll file it, and that's the complaint. It'll lay out, who is alleged to have committed what crime, general date and time, the jurisdiction, things like that. So that's a criminal complaint. An indictment, which is required by several jurisdictions, including Texas, is a slightly more formal charging instrument. An indictment is basically going to look the same, but it will be a return of the original complaint after it's been looked at by a grand jury. So a grand jury is selected from the citizens of the county. They sit for a certain amount of time, and cases are presented to them by the district attorney's office. The grand jury's job is then to look at the complaint, any initial evidence or information that's available, and make a determination as to whether or not there is sufficient probable cause to continue with the case. If they do decide so, they return a true bill, which is basically saying yes on the complaint, and the document that's signed is now an indictment.
Okay, so for you as a defense counselor, I believe you told me you've been able to be there in general, right, for your own clients, but are you able to present evidence to counter that complaint?
In a limited capacity. Grand jury proceedings are secret. It's designed to protect the grand jury from external influence. The only members allowed inside and with the grand jury when they convene are the prosecuting attorney, the prosecutor. He presents the case, and any witnesses that the grand jury might request to testify. It is possible for me as a defense attorney to request to present a packet to the grand jury, which the DA can present. It's just a compilation of things that may be relevant to the grand jury, and we think the grand jury ought to know when deciding whether or not there is sufficient probable cause. But no one other than the district attorney presenting the case is permitted or has a right really to be in there with the grand jury when they're convened. The grand jury has the power to request witnesses, but no one else has a right to be in there.
I see. Okay. Then when you say secret, would that also mean that, for example, the defendant's name is not disclosed, or even the complainant's name, victim's name?
No, not in that sense. It's secret insofar that
just
no
the
one's
people
permitted inside. It's
okay.
Yeah, like
that. What's your general sense now that you've heard, especially for what you read about the different charges and or elements of those charges in Minnesota, and knowing what you know about criminal defense practice, I think you already alluded to this earlier, but do you think this will be a swift um, verdict, or do you think there's any room for Derek Chauvin to get a lesser charge?
That's
Or to be
that's going to be a pretty complicated question.
Mhm. I
I
know
don't
you
think
can't predict the future, but just based on your experience.
I don't think that the trial is going to be short by any means.
Mhm.
And just based on that fact, I don't think the jury's deliberation is going to be swift. They're going to have a lot to think about. They're going to have a lot to recall and consider. Um, the third degree murder and the second degree murder charges are basically entirely different. They're different ways. I mean, yes, they're both accusing the officer of murder, but they get there in very different ways. Um,
Mhm.
one lays the predicate for murder by saying that the officer caused the death of another individual in the process of committing a felony. That would be the second degree charge, the felony murder charge. The other one says that the officer, in the course of committing an act inherently dangerous to human life, caused the death of another individual. Uh, they're similar but legally very distinct.
Mhm.
And so,
Then the I'm sorry to cut you off. Did you have something to
oh,
add?
go ahead.
So then the second degree, you said the felony murder. In this situation, what is the felony itself?
So, my understanding is felony in the felony itself here would be an assault, uh, maybe even aggravated assault. Most likely, an aggravated assault by the officer.
So I know in Texas, at least, there can be a charge of aggravated assault with a deadly weapon. Is that required in Minnesota? Were you able, have that reading?
Um, no. So the interesting thing is that Texas also has a similar concept of felony murder. But Texas's felony murder statute is a little bit more restrictive in that basically for felony murder, you need an underlying felony. In Texas, that felony can't be a lesser included assault.
Mhm.
By that I mean, like, if the underlying felony is aggravated assault, uh, that's not itself sufficient to support a felony murder charge, because what
Mhm.
happens then is the intent element is basically removed. Normally, if you wanted to charge someone with murder because they assaulted someone and they ended up dying, you would need to
Mhm.
prove something about the intent or the mental state of the defendant. But if you just say, hey, he committed a felony of aggravated assault and someone died, and then instantly then there's no intent requirement.
Mhm.
Uh, and so that's not how felony murder statute was intended to be used. And so Texas is slightly restricted felony murder in saying that the underlying felony cannot be a lesser included of murder itself,
So,
manslaughter or assault.
so it sounded like in Texas for felony murder, you can't use the intent of an aggravated assault and substitute in for murder.
That's correct.
Okay, and so you're saying in Minnesota, it's a little bit more open in that sense of the definition.
Yeah, so from what I've looked at, I don't see any restrictions on the underlying predicate felony that can be used for a
Mhm.
felony murder charge. Uh, I might not have looked at everything. There might be case law that expands on what their statutes say, but I have not found it.
Okay. Well, thank you for sharing that and unpacking all those different definitions and nuances, because I think in general, when we watch the media or traditional TV, we don't we don't take the time to understand that criminal law or many different practice areas in general is specific to that jurisdiction or to that state, especially criminal law. So even if there was some kind of not guilty or guilty verdict, it'd still be interesting to see how it plays out in other recent deaths of, for example, Mr. Brooks in Atlanta.
Right.
Mhm. Well, now just taking a step back. Well, do you have anything else you'd like to share about the George Floyd's case?
Um, well, I think we covered most of it. I think
Mhm.
it's going to be interesting. The other interesting thing, I suppose, is the other officers who were on scene there.
Right.
Um, my understanding is that they've also been charged. They've been charged not directly under the statute, but Minnesota has provisions for roughly what we'd call accomplice liability. They've been charged as aiding and abetting
Mhm.
um, Officer Chauvin in the murder. Minnesota law basically makes them liable for the same offense as the officer who actually caused the death of Mr. Floyd under the aiding and abetting statute that they have, and so they face up to second-degree murder charges as well.
So I don't, of course, your experience and your bar license in Texas. So my next question is, of course, I don't expect you to answer specific to Minnesota, but at least in Texas, do you need the intent of being an accomplice or aiding and abetting before, let's say, you arrive to the scene?
Um, Not generally. There are a couple of, I guess, situations where it can depend. Um, and I think partially because the specific statute that I understand the other officers have been charged with under Minnesota are a little different from how things work in Texas. Um, but general theories of accomplice liability can and fall roughly under two different categories, at least in Minnesota from what I can see. One is aiding and abetting, that fairly simply means, helping or taking part in the offense that the principal is charged in.
Mhm.
And in Minnesota, that's the aiding and abetting statute. And the other way, well, let's come back to the first one, is that so
Mhm.
in that sense, you need not have necessarily had the intent to have the end result, right? I mean, right now it seems like I don't even think the state is contending that Officer Chauvin had an intent to kill Mr.
Mhm.
Floyd. Simply that he's charged with second-degree felony murder. He committed a felony and caused the death of an individual in the course of doing it. And so the only intent that the state really has to prove there is that the officer intended to commit the underlying felony of probably it's going to be aggravated assault. Um, so the accomplice liabilities, they need only have intended to assist, not even necessarily intend for the aggravated assault to happen.
Mhm.
That's, I guess, the ease of charging in accomplice liability.
Hmm.
Um,
Okay. So, in at least in my experience, bar exam questions, assisting could be, for example, or what people watch in the movies, the assisting could be driving the getaway car. But in this situation, from what I've seen in the video, it appeared the officers that were there were not doing anything. In
mhm.
fact, of course, everyone in public thinks they should have stopped Mr. Officer Chauvin, but they literally didn't do anything. So, do you think they could be still convicted of accomplice liability for omission, basically?
Um, Possibly. So that is going to be a little bit beyond what I've actually looked into.
Hmm.
Um, Generally speaking, there is no duty to act for regular individuals
Hmm.
in I guess basically this kind of circumstance. However, the officers who were also on scene, but not the one who are directly responsible for Mr. Floyd's death, are not like everyone else. They are under a duty to act by virtue of their position, and
Hmm.
so failure to do something uh, could constitute an omission that omission of an action that should have been and was required. That starts getting really complicated in terms of how Minnesota law defines that, which I'm probably not qualified to answer. But I would suspect that it may go something along those lines, that they had a duty to do something and they didn't. And
because of their professional capacity, right? As a public servant.
Yes.
Okay.
And so when they failed to do so, that was a criminal act, and basically saying not doing anything, and they were required to, and not doing something they, aided and abetted by not doing something when they were required to.
Right. To contrast that, because I've heard of other people, let's say on Facebook or something, saying, well, why didn't the person who were nearby, like the people in the public in general, not intervene? Well, you and I know it's best not to intervene, because especially when there's multiple cops there, you could be in a situation like Mr. George Floyd too, unfortunately, for intervening. But like you said, there is no duty for someone in the public to intervene.
That's correct.
To contrast that situation with a police officer, a public servant.
In Texas, we don't have degrees of murder.
Oh, right.
Like, I don't really understand how their degrees of murder actually impact anything, other than they're just listed as like third degree, second degree murder, and then within their own penal code, they've got sentencing guidelines. But for all theirs, for second degree murder, which is just what it's called in Minnesota, the maximum is 40 years. In Texas, we don't have that. Like, in Texas, murder is either, I think all murder is going to be first degree felony. First degree felony has the normal, like, enhancements and stuff aside. First degree felony is 5 to 99 in Texas.
Oh, okay.
Second degree felony is 2 to 20. Third degree is 2 to 10. So, like, there are these huge ranges. Obviously, some offenses are going to have specific enhancements and stuff. Like, some will have a floor. True habituals will be like, 25 to life. But in Texas, felony murder is just 5 to 99. I mean, if it's a capital case, which is a determination based on other things, it's just, if it's guilty, it's automatic life or death.
Oh, yeah, capital murder too. And that can include, like, when you kill a cop or something, right?
Yeah, like if you kill a cop, if it's premeditated and the DA wants to pursue it as a capital charge, because, like, let's say if you ambush someone, that clearly meets the definition of capital, right? I mean, it's premeditated. Here, if they were all charged with felony murder, fairly certain that's going to be a first degree felony. They're looking at 5 to 99. Like, that's a massive difference in sentencing. And there's no floor for them. Theirs is just 40 years max for second degree murder. Like, their sentencing scheme is completely different. It's a little
Wait,
whack.
first degree murder? He's not charged with that, but first degree murder can minimum is 5?
Well, so no.
We'll call you back for another interview, the unfortunate death of Mr. Brooks. But to take a step back, we'd like to learn a little bit more about your own practice. Some of the people in the audience are younger lawyers or just like less experienced attorneys. For those that are thinking about getting into criminal defense, are there any general tips that you would offer?
Depending on how long they've been practicing, the tips might differ a little bit, but I would generally say that if you're interested in criminal defense, but you don't have any experience, I'd say that the best thing to do would be to try and find a mentor. They don't have to give you a whole ton of time, but basically you need to figure out and find out for yourself what it actually means, and like what you're going to be doing on a day-to-day basis. I mean, I can tell you, but that doesn't really get the point across. If you can get an attorney to let you shadow him as they, attend settings and criminal hearings and just, see what they do on a day-to-day basis. Obviously, that's going to take some time investment, but that is the best way to get an idea of what it is that you'll be doing in the course of being a criminal defense attorney. I would also highly recommend sitting in on a trial, basically the entirety of the trial if possible. It might last a couple days, but that that is also going to be pretty decent experience in terms of learning what a trial looks like.
Absolutely, I agree with that. Before I started practicing immigration law, or right at the start, I attended and observed immigration hearings in Dallas, Texas. Um, before we talked about, like court efficiency, when you actually appear in court for settings, can you explain what a setting is? Because from my understanding, in the criminal context, sometimes you don't actually see a judge, right?
Yeah, so I think this may differ a little bit from jurisdiction to jurisdiction, but at the very least in Harris County and the surrounding counties that I've practiced in, settings don't necessarily mean a lot. Generally, once a defendant has been charged, let's say they're arrested, they've seen a magistrate judge, bond is set and made, and they're released, they'll receive a court date that they have to come back in.
Mm-hmm.
And then from that time until the case is resolved, they will have to generally continue to come in after every single time. Generally, in the past, at about a month's interval. These are what we refer to as settings. Oftentimes at these settings, the defendant will have no contact with the judge, will have very little interaction with any part of the judicial process other than with their attorney. These settings are one part, for the judicial system to make sure that the defendant is still on bond, still reporting in, and hasn't absconded. It's another opportunity for the attorneys to meet in person, discuss the case, exchange evidence, things like that. But a lot of times, no, the defendant will not have any contact with the judge or the prosecutor at all.
I see. So in that sense, especially with the coronavirus period or COVID-19 this year, do you think that it could be more fit? Have you observed, or in your experience this past 34 months, that prosecutors are being more efficient in terms of sharing evidence, for example, or just conversing with you about the case over the phone or video?
I would not say that I've seen that.
Mm-hmm.
Honestly, what I've largely seen is cases basically stall out
Mm-hmm.
for the most part, and I don't know that that's entirely on the DA's head. Like I don't want to say that that's their fault. I mean, largely, like the courthouse has been locked down for
Right.
the better part of almost 3 months. As a result, the courts have been resetting, basically almost unilaterally, the court settings, which I mean, understandable. The precaution of not having hundreds, if not thousands, of people crowded into a courthouse, it makes sense.
Right.
And so the settings have been just pushed back by months. Also, no jury trials have been taking place at least in Harris County and probably surrounding counties that I understand. And so a lot of cases have largely just stalled out. I think I read an article the other day that pending cases in Harris County felony courts have increased by almost 10,000 in terms of they're just pending, like they've not yet been resolved.
Mm-hmm. Well, at least for immigration, for me, my practice, in terms of conversing with the government attorneys with Department of Homeland Security, it seems that they've been more amenable to either dispose of cases, to finish cases out if possible, just see if there's any agreements we can make, at least with some of the elements, maybe not entirely the whole case.
Mm-hmm.
Especially with COVID-19, I was able to get one client who was detained to be released because we were able to provide what we thought sufficient evidence that one of her sons needed surgery soon, in spite of the COVID-19, and that shows how significant the need for the surgery for the son. But every case is different, of course. But that's just what I witnessed and observed with immigration practice.
That is interesting. I mean, I assume that a lot of your hearings have now been performed over Zoom or by other electronic means.
Right. So for the cases that are hearings that are, or clients who are detained, Yes, those cases have still been moving forward in terms of still being conducted during this coronavirus time. But cases where people are non-detained, meaning they're living at their own home, those cases have been postponed. And not all court, even though it's a federal practice, not all courts have been open for the or have an intended date to open for non-detained cases. It really depends on the state itself. For example, in Texas, there's no longer a stay-at-home order, or I think it's on phase 2 to 3. So they've EOIR for the immigration court system. They've already announced that they were going to resume non-detained cases in mid-June, actually.
Okay.
And I'm sure that still freaks out some people in the public, witnesses, for example, and even practitioners on both sides of the aisle. So more to come on that. But yeah, we'll like to invite you back to speak about other topics on criminal law, and for example, with the COVID-19 and how people, defendants are able to get released in this time period.
Yeah, sure. No, I'd love to be back.
I appreciate it, James. Well,
Okay.
thank you very much. And one last thing for you, if I can ask you, what is the best way for people in the public to contact you? I know you said you practice in Harris County and surrounding areas. And for those that don't know, Harris County is the main city is the city of Houston, Texas.
Yeah. So, I mean, our practice is basically Harris County and most of the surrounding counties, Fort Bend, Montgomery, Brazoria, but mostly in Harris County. If anyone wants to contact us or needs the services of criminal defense attorneys, I'd be happy to talk with them.
Well, James, we'll actually provide your contact information in the description below. So in case someone's in the area in this jurisdiction that you serve, that hopefully they can contact you, at least get a consultation, right?
Right.
To
Absolutely.
see what the strategy could be for them. Thanks, James.
All right.
You have a great day, sir.
Thanks for having me. Bye,
Be
John.
safe. Thank you for watching Lawyer Up. I hope you learned something from today that you can share with others. If you enjoyed today's content, please click subscribe below and click the bell to receive notifications for our next episode. Expect an episode every Monday by 8 a.m. We'll even drop bonus episodes during the week. We have an amazing lineup of leaders and entrepreneurs ready to share their life's work to make a difference. Hey everyone, if you have any questions or comments, please type that down below and we'll answer them as soon as we can. Thank you very much. We'll see you next Monday.